supposed to be here, who wants to be here, is already here. So welcome to today's event with Law Students for Life and the Federalist Society. Today's event is, does the 14th Amendment prohibit abortion? We are so excited to have with us two amazing speakers, Jonathan Adler and Josh Hammer, and then Clark Forsythe, our wonderful moderator. The format of today's event will be, I will give the speaker introductions, and then I will turn it over to Clark to introduce the debate. From there, he will moderate the debate between Professor Adler and Josh, and then he will open it up to audience questions. So if you're wondering about something with the debate, if you want to ask a question, you'll have a chance to do that at the end. So I will go ahead and introduce our speakers. Josh Hammer is opinion editor of Newsweek, a research fellow with the Edmund Burke Foundation, counsel and policy advisor for the Internet Accountability Project, a syndicated columnist through Creators, and a contributing editor for Anchoring Truths. Prior to Newsweek and the Daily Wire, where he was an editor, Josh worked at a large law firm and clerked for a judge on the U.S. Court of Appeals for the Fifth Circuit. Josh has also served as a John Marshall Fellow with the Claremont Institute. Josh graduated from Duke University, where he majored in economics, and from the University of Chicago Law School. He lives in Miami, but remains an active member of the State Bar of Texas. Jonathan H. Adler is the inaugural Johann Verhege Memorial Professor of Law and Director of the Coleman P. Burke Center for Environmental Law at the Case Western Reserve University School of Law, where he teaches courses in environmental, administrative, and constitutional law. Professor Adler is among the most cited legal academics in the fields of environmental and administrative law, and his articles have appeared in publications ranging from the Harvard Environmental Law Review and Supreme Court Economic Review to the Wall Street Journal and USA Today. Prior to joining the faculty at Case Western Reserve, Adler clerked for the Honorable David B. Sentell on the U.S. Court of Appeals for the District of Columbia Circuit. He holds a B.A. magna cum laude from Yale University and a J.D. summa cum laude from the George Mason University School of Law. Clark Forsythe serves as senior counsel at Americans United for Life and is author of Abuse of Discretion, The Inside Story of Roe v. Wade. Clark has argued cases before federal and state courts and has testified before Congress and state legislatures. He is also a prolific writer on pro-life policy issues, having published more than 19 law review articles and book chapters, as well as articles in First Things, The Wall Street Journal, and National Review. Other leading newspapers that have published his articles or quoted him include the New York Times, the Los Angeles Times, USA Today, the Washington Times, the Washington Post, the Chicago Tribune, and the Wall Street Journal. Clark has a BA in political science from Allegheny College, a law degree from Valparaiso University School of Law, and a master's in bioethics from Trinity International University. Please join me in welcoming our speakers.
Thank you, Elle, and welcome everyone. As I understand the question today, to phrase it in a more perhaps textual way, is the unborn child or prenatal human a person within the meaning and the protection of the 14th Amendment? This question actually goes back, at least being briefed in the Supreme Court, I think about 50 years to, I think the first time, at least by amicus, was United States versus Vuitch in 1971. Which, as you may recall, involved the D.C. Abortion statute. And Vuitch preceded Roe and was actually the first modern Supreme Court case on abortion that the courts addressed. Of course, in Roe versus Wade, the court addressed it briefly, and the majority held that the unborn child was not a person within the 14th Amendment. But it has been kind of a perennial issue, at least addressed by amicus in a number of Supreme Court cases over the years, probably briefed in 20 or 30 cases. So the justices have heard at least many of the arguments over the years. But I think it's also a rich question about the 14th Amendment. How do we properly read the 14th Amendment? What is the role of text and context? Is the legislative history relevant? And what do we find in the legislative history on this question? And then I think it raises, or the implications raise, profound questions about federal and state enforcement of the 14th Amendment. Is federal enforcement superior? What is the role of state enforcement? And what might be the implications for state or federal enforcement if the unborn child was found to be a person within the meaning of the 14th Amendment. So Elle laid out our format, and Josh is taking the affirmative position, so we're going to let him start. Thank you.
Okay, can breathe again. Well, thank you for that, Clark. Thank you, Elle. Thank you, everyone. So it's only my second time being back here to speak since I graduated. It's always great to be back here, obviously. This is quite the crowd. Look like, based on some stickers that I see, that were mixed on the underlying substantive policy issue here. This is obviously not a policy debate. This is a legal debate, but I'm sure the Q&A will get into all sorts of fun stuff as well. I was known to be a bit of an interlocutor provocateur myself when I was in your shoes in the audience, so I don't begrudge you for asking anything that your mind desires. So a lot of people kind of look at this debate and they immediately think that my side of this debate is coming to this in bad faith. But the history of this argument, at least in kind of amicus briefs of the Supreme Court, as Clark has outlined, goes back quite a while. This is not a new thing. This is not like a newfangled thing that some of these like crazy people, most of whom are my friends, crazy people like on Twitter, they're like are coming up with this. This argument does have kind of a longer history here. I mean, the reason that this has kind of re-emerged a topic of discussion over the past year, a couple of years, is largely due to the First Things magazine article from John Finnis in the April issue of First Things, where he argued, it's like an 8,000-word essay, abortion is unconstitutional. That was the argument that he put forth. It was a kind of iterative back and forth with Ed Whelan. But really this kind of started get going really in 2017 when a dear friend of mine, Josh Craddock, had a note, I guess when he was a 3L at Harvard Law in the Harvard Journal of Law and Public Policy, making the affirmative argument for prenatal personhood under the 14th Amendment. Michael Stokes-Paulson of the University of St. Thomas Law School had first kind of floated this in 2013 in a law review article about the, quote, plausibility of personhood. He did not kind of truly come down one way or the other on the issue, but he was kind of discussing that this has a lot to it. And even kind of a lot of the people like Ed Whelan who have traditionally been hostile on the right to this view usually are when they're open about it, they acknowledge that it's a non-frivolous argument. So Professor Adler, to his great credit, I think when I saw on Twitter, Jonathan, you were getting some heat for this, and you pushed back and said this is a legitimate debate. So good stuff. Happy to be here. So let's kind of take it back to kind of bare bones here. So I'm just going to read Section 1 of the 14th Amendment. Quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws here. Now, the argument in Roe v. Wade that was put forth by Justice Harry Blackmun in 1973 primarily relied upon the argument that the unborn child is not a person under any meaning or any proper construction of Section 1 of the 14th Amendment. But to his great credit, in what is otherwise obviously a truly dreadful and horrific opinion, he had the moral clarity, the moral forthrightness, or at least the intellectual honesty, we might say, to acknowledge that the argument in Roe completely collapses, utterly collapses, under the Due Process Clause and or the Equal Protection Clause if an unborn child is a person under either of those provisions here. Now, there's a lot of kind of other sloppiness in the Roe opinion. It relies heavily on two pieces of scholarship from Cyril Means, who passed away probably about 30 years ago or so. He was kind of a pro-abortion advocate for NARAL back in his early days. His quote-unquote scholarship was shoddy, to put it mildly. It's been refuted, rebutted. I can send you links to that if you want. I'm not going to spend much more time on that. He basically argued that the right to abort, so-called right to abort, was kind of a, quote, common law liberty, just total, complete nonsense. But the main thrust of Harry Blackmun's argument is this notion that the unborn child is not a person under the Due Process Clause and or the Equal Protection Clause. However, in the year 2021, given the state, obviously, of human embryology and what we now know about the science, the capital S science that we've heard so much about for the year and a half from, or Dr. Anthony Fauci, people like that, we know that the unborn child literally is a person. In fact, My friend Steve Jacobs, who just got his PhD from this university, the University of Chicago, I think he got in 2019 or maybe it was 2020 when they finally gave it to him after some bureaucratic holdup. He literally dedicated his dissertation to this very question. He asked a global survey of 5,502 biologists. 5,502 biologists. He asked them, when does human life begin? 95% of all biologists affirm the biological view that a human's life begins at fertilization. 5,212 out of 5,502. I just want to briefly pause. I think, from my perspective, the argument literally can end there. That theoretically could be it. That could be ballgame, end of story. If you compare this kind of just like standard originalist methodology and how it works in kind of other constitutional provisions here, even if the ratifiers, the drafters of the 14th Amendment did not ratify the term persons with this kind of understanding at that time that it encompassed prenatal human life, we can easily analogize that to, let's say, the First Amendment, for example. The First Amendment, the Free Speech Clause, films, movies. There are any number of technologies, obviously. There are any kind of possible obvious kind of examples as to what speech entailed in 1791 when the First Amendment Bill of Rights was ratified that they did not foresee. And this kind of gets obviously to kind of inside baseball kind of debates about kind of like original expectations, originalism, original public meaning original and so forth. But under kind of standard prevailing OPM originalism, original public meaning originalism, holding aside any of the common good originalism with which I've kind of become synonymous, holding aside any of that, under standard kind of OPM public meaning originalism, from my perspective, the debate literally could end right there. We see this, again, this is standard original stuff. You can go to the Fourth Amendment, searches and seizures. Well, we talk about searches and seizures now of computer files, of internet technology, any number of things in the quote-unquote effects to which the Fourth Amendment refers that the founding generation never could have possibly, obviously could not have foreseen. So, look, it's interesting and it's worth noting that no kind of conservative or originalist justice, obviously, has endorsed what I'm saying. They've kind of implicitly accepted Harry Blackman's argument that the unborn child, in fact, is not a person under due process and or equal protection clause. But again, what if even holding aside the Steve Jacobs dissertation and this modern, really kind of 95% global biologist beyond a shadow of doubt consensus that the unborn child is a biological person of the Homo sapiens species, what if even the ratifiers and the draftsmen, when they ratified the 14th Amendment, actually understood and recognized that person was that? So it's worth kind of going back in history a little bit here, and my time is already quite short. This is a truncated debate, but I'll try to be quick. If you think about what kind of what Blackstone would refer to as the ratio legis, the reason of the law, like what kind of operated and undergirded the 14th Amendment, it was really meant to kind of constitutionalize the Civil Rights Act of 1866, which President Johnson, of course, was no great big fan of and faced kind of other constitutional obstacles. The Citizenship Clause, the very first clause of Section 1 of the 14th Amendment, was meant expressly to overturn Dred Scott. But really kind of the ratio legis here, the overarching purpose was to kind of instantiate and constitutionalize the Civil Rights Act of 1866. And the drafters of the Civil Rights Act of 1866 really could not have been more clear about this. When they were talking about kind of the fundamental rights of man, again, 1866, we are a year removed from leave surrender to granted Appomattox. This is kind of what is undergirding the country is trying to codify the fundamental rights of man. That's what's going on in 1866. That's what's going on when John Bingham of Ohio takes the lead pen in the 14th Amendment 2 years later in 1868. So when they were thinking about, at the time, what was kind of the lead text, what was the lodestar, what was kind of the guidepost to kind of guide them when trying to kind of conceptualize and formulate and ultimately codify the fundamental rights of man, there was no more obvious place to start than the most famous and influential English common lawyer at the founding, which was Sir William Blackstone. So, Abraham Lincoln famously said, when I'm trying to learn the law, where do I start? The commentaries. Read it once, read it twice, that's where you start. Blackstone's commentaries on the law literally began. It began with a discussion of unborn children's rights as persons. And state high courts, actually, in the years before 1868, oftentimes did declare that unborn human beings throughout pregnancy, quote, are persons, and therefore, quote, under civil and common law, are, quote, for all intents and purposes, a child as much as if born. Blackstone, I just cannot emphasize enough here. James Wilson, who was the chairman of the House Judiciary Committee, which obviously had jurisdiction over drafting and ultimately ratifying the 14th Amendment, said over and over and over again that he was trying just to codify the commentaries of Blackstone. Blackstone was he was unambiguous about this. And in fact, in the decade or so, or at least 15, 20 years leading up to 1868, we saw this playing out in state after state. So the Union in 1868 was 37 states. 30 of them at that time had statutory abortion prohibitions, most of which were defined, quote, as offenses against the person. In the criminal laws, the criminal statutes of the states, the abortion proscriptions were defined as, quote, offenses against the person. 27, by the way, of these 30 states had criminalized abortion both before and after so-called quickening. Quickening is kind of an antiquated term. We don't hear much anymore. It refers to when, a woman or a birthing person these days, can feel the unborn child stirring in the womb. So a lot of the critics of what I'm saying, kind of the Ed Whelans of the world, often kind of take a strong stance on the purported quickening distinction, but that distinction actually had already been collapsing. I mean, quickening was really kind of a flexible, moving target, much like quote-unquote viability from the Planned Parenthood versus Casey atrocity is in a modern context. And it was really just there as kind of like an easily administrable standard of proof. It was not a substantive value judgment, and was always understood that as greater understanding of human life been, that this would kind of naturally progress from there. The Pennsylvania Supreme Court in 1850 said, quote, "The moment the womb is instinct with embryo life and gestation has begun, the crime of abortion may be perpetrated. There was therefore a crime at common law." And the American Medical Association, 1859, 9 years before the 14th Amendment was ratified in 1868, dismissed this fiction, quote, "that the fetus is not alive until after the period of quickening." So it really would be more accurate to say that the common law prohibited abortion in utero according to the best medical knowledge of the day. Quickening was really just kind of a convenient, judicially enforceable means to do that here. So having said all that, there are a few obvious objections to what I'm saying. I kind of want to preemptively rebut some of the obvious ones. One of which was a line that Harry Blackman invoked over and over again in the Roe v. Wade argument, which was he basically said, okay, well, even if this is true, the word person applies elsewhere in the Constitution where it clearly has some other context, right? Well, not necessarily, right? So if we go back to the 14th Amendment, Section 1, the Citizenship Clause, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens." Well, the inclusion of "or naturalized" by basic canon of construction implies that there are some persons not in the category of those who have been naturalized, so there are some unnaturalized persons. Applying that exact same canon of construction to the "or born" provision necessarily implies that there are some category of persons who are not born here. And even in various other places where this comes up, this quote-unquote gotcha point here, we can think about kind of the presidential eligibility criterion, right, where you have to, all persons who have attained the age of 35 are eligible for president. It's not the verbatim language, but that's basically what the provision says. That doesn't mean anything. That literally gets you absolutely nowhere. All persons who attain the age of 35, that implies nothing whatsoever as to whether a person was a person under the Equal Protection Clause and or the Due Process Clause. It simply is, the conclusion simply does not follow from the purported premise of the arguments here. More generally also, corporations kind of under 14th Amendment Equal Protection Clause are generally construed as persons. Going back to the Dartmouth College case of 1819, famously argued by Daniel Webster. There's a Santa Clara County case of 1886, which was kind of the first time that the court said that corporations are persons under the Equal Protection provision of the 14th Amendment. And by the way, John Bingham, again, the Republican of Ohio, who was the lead draftsman of the 14th Amendment, went out of his way to say that from his idiosyncratic perspective, he didn't care about corporate persons. What he was trying to do in the 14th Amendment was about natural persons. But the court only 15 years later said, we don't care, because the logical corollary is not what you idiosyncratically had in mind here, but is the logical consequences of your position. So one other quick kind of gotcha point here is judicial enforceability. How do courts go about doing this? Well, there's two responses to that. One is... 1 minute, okay. So, real quick, there's a whole body of case law as to how courts go about enforcing equal protection claims. We can go into that if you really want to. It starts with the Gitwoe case, the 1880s. This is not that hard. It doesn't turn to the roving legislatures, roving police that people think it does. But more generally here, there was a rich body of evidence, and I subscribe to this theory wholeheartedly, that the way that this was meant to be enforced was actually not by the courts, but by Section 5 of the 14th Amendment. It should come from Congress. Congress has the enforcement power under Section 5 of the 14th Amendment to actually directly legislate, to effectuate and bring into action the tenets of Section 1 here. So that is actually where this should come from here. But look, if I could just very, very, very briefly end on a very quick note here. We're having this debate in Chicago. Chicago, of course, is a city where Abraham Lincoln kind of rose to fame at Wolf Point, there just on the North River. I'm born on Lincoln's birthday, and Lincoln's my favorite hero in American history. Lincoln, in his 1850 Peoria speech, which is kind of a forgotten speech, one of the great ones, famously said that when it comes to the doctrine of self-government, he was kind of preemptively rebutting Judge Douglas's arguments 4 years later. He said when it comes to the doctrine of self-government, the relevant question, to use his language, the relevant question is whether the Negro is not or is a man. If he is not a man, why in that case he who is a man say as a matter of self-government? So just as then the question for Lincoln in the great debates of the age was whether or not black people were or were not persons, so too is the great debate now whether the unborn child is or is not a person. And that's not even a close call. The answer is yes. So.
It's a pleasure to be back at the University of Chicago. I always enjoy my visits here. It's great to see a full room of folks eager to hear debate, and I appreciate the opportunity to be here today with Clark and Josh to discuss this question. As an initial matter, let me just say, I don't think this is a frivolous argument. Robbie George, John Finnis, serious scholars who've done serious historical work that shows that a lot of what we read in our casebook, a lot of what we think we know about the history of this question isn't quite as clear as we thought it was. It's a serious argument, and I would say it's an argument that's as serious or perhaps even more serious than some that we've seen adopted by courts. It is nonetheless wrong. It is a serious argument that I think fails. As someone who was a college debater, I'm going to at least initially start and stick with the resolution we were given, which is, does the 14th Amendment prohibit abortion? And I do that for two reasons. Because I think for that to be true, there are two things we have to accept. First, we have to accept that the unborn child is a person for purposes of the 14th Amendment. And then we also then must accept that a state failing to prohibit abortion or perhaps to treat abortion equivalent with other forms of killing constitutes a violation of either the guarantee of due process or equal protection under the 14th Amendment. Those are separate claims. They both must be true for the 14th Amendment to prohibit abortion. There is an auxiliary question, which Josh raised at the end of his remarks, which we can also get into about, well, what about Congress? Could our position instead be a unborn child is a person for purposes of the 14th Amendment, at least insofar as invocation of Section 5 of the 14th Amendment? Time permitting, I'll get into that a little bit. That actually raises a bunch of other questions about the nature of Congress's power under Section 5, which may be somewhat independent of the meaning of Section 1 of the 14th Amendment, but we can certainly get into that too. Now, why do I say that the argument that the 14th Amendment prohibits abortion is wrong? Well, let's start with the question of whether the unborn are persons for purposes of the text of the 14th Amendment. I too have my Cato Constitution complete with the Declaration of Independence, and I think it's that fun little Roger Pilon essay. If we look at the text of the 14th Amendment, we see reference to persons. If we look at the history of the 14th Amendment, we know what it was meant to do. And if we look at its effect on structure, I think we have an understanding of how it, in many respects, fundamentally transformed the nature of our Constitution. But I think if we look carefully and closely at text, history, and structure of the 14th Amendment, it is hard to come to the conclusion that it establishes that the unborn are persons for purposes of the 14th Amendment, and particularly difficult to claim that it provides that the failure to criminalize abortion would constitute a violation of either the guarantee of due process or equal protection, which again is also necessary if we are going to say the 14th Amendment itself prohibits abortion. So let's start with text. The word persons is used throughout the Constitution. It's used throughout the 14th Amendment. In the vast majority of uses, it can only have meaning as applied to those who are born. Just look at Section 2 of the 14th Amendment. Just look at provisions relating to apportionment. Now, this is not by itself enough to establish that the unborn are not persons for the purposes of the 14th Amendment. But we do see throughout the Constitution the use of the word in a way that it cannot apply to the unborn. It is true that Section 1 begins in the Citizenship Clause mentioning those who are born or naturalized as being citizens, but I think the fairest reading of that language is not that it is to distinguish those who are born versus those who are unborn, but those who are born here as opposed to those who were born somewhere else. There are two ways to be a citizen. One is to be born here, one is to be naturalized. That is the purpose of that language, and I think in fact that language suggests that being born is of meaning, is of significance to being part of the political community. If one understands that the 14th Amendment is at its core being about being a citizen of our community and what then flows from that, and recognizing that's actually not the Due Process Clause and Equal Protection Clause that are the primary guarantor of substantive rights under the 14th Amendment, but the Privileges and Immunities Clause that protect the privileges and immunities of citizens, one then understands why the best reading of Section 1 is that the reference to born and naturalized is not to distinguish among born from unborn, but distinguish those that are citizenships by reason of birth or naturalization from those who were not born here and therefore are not citizens on that basis. The corporations argument, yes, we have some Supreme Court opinions saying that corporations, because they are collections of people, do not lose the rights that those people have when they form together in groups to do things. And that's true whether they form a railroad, or they get together to form a chapter of the Sierra Club, or to form a church, or to anything else that we recognize as using the corporate form. The word person does not apply to corporations throughout the Constitution. It only applies where that logic, where what we are doing is protecting the rights of the underlying individuals, is necessary. So, for example, corporations are not protected against the right of self-incrimination. We are. Corporation as an entity is not. Corporations are said to have First Amendment free speech rights, but note that that language in the First Amendment is not about the rights of persons, it's about limitations on government. Limitations on the government's ability to suppress speech and press without regard for who is doing it. So I don't think the history of the corporation and its treatment by the court and by commentators tells us that the word person is somehow more capacious or should just be open to more flexible readings than a direct reading would allow. I think the history is the most important part of this question. Because it is certainly true that at the time of ratification of the 14th Amendment, the majority of the states criminalized abortion. They did not treat abortion or feticide as equivalent to homicide, which is important for consideration of equal protection, as I'll get to in a moment. In fact, it was rare to treat them completely equal, to treat them as the same crime. But it was also not universal. Throughout history, under the common law, prior to ratification of the 14th Amendment, after the recognition of the 14th Amendment, those jurisdictions that treated abortion as a crime did not treat it as equivalent to murder, did not treat it as the same offense, regularly treated it as something different. Something that many states, many regions sought to prohibit, but not something that was the same as homicide. As Josh noted, 10 states, at least 10 states, did not prohibit abortion prior to quickening. 7 did not prohibit abortion at all, nor did the District of Columbia or federal territories. Which is interesting because we've had a Fifth Amendment due process clause that is applied to the federal government since the beginning, and the federal government never saw that as imposing an obligation to prohibit abortion as required by the need to guarantee the life, liberty, and property of all persons under that due process clause. When we look at the history, what's also more interesting, though, is that it's true. At the time of the ratification of the 14th Amendment, there was a increase in concern about abortion. There was an increase in the enactment and the tightening of statutes relating to abortion throughout the country. But what we do not see at all, or at least I've not yet to see anyone point this out, John Finnis and Robbie George, despite their extensive research into this history, Joe Della Penna's extensive research and so on, do not show is a single legislator saying the reason we are enacting this new abortion law in our state is because the 14th Amendment requires us to. There is not a single, even though the debate about the status of unborn life was a significant political issue in the middle of the 19th century, we don't see anyone connecting it to the 14th Amendment. We don't see anyone connecting it to the guarantees of the 14th Amendment to due process and equal protection. This is not a case like we see in many questions about constitutional interpretation where there are vigorous debates and we're trying to understand whose understanding of the language is best reflected in the text that's eventually adopted. That's a kind of debate we see quite a bit. To what extent do we read the Federalist Papers as really encapsulating what the Constitution did? To what extent do we have to recognize the Constitution's language was tweaked in ways to account for certain? Here it's nothing. We also see quite a few states that didn't change their abortion laws after enactment of the 14th Amendment, after its ratification. That didn't tighten them, that didn't move to try and treat abortion like murder. And yet we don't see the outcry that this somehow represented a violation of the 14th Amendment or a failure to abide by the strictures of the 14th Amendment. And silence this broad is quite significant. Further, as I also noted, if we think that the Equal Protection Clause requires treatment of the unborn as the same as those who were born, that was not even in the case throughout much of the country that did criminalize abortion. Abortion was not treated as murder. It was treated as something different. Feticide was generally considered a separate offense to homicide. The other point I think that's important to then talk about is structure. I have 4 minutes, is that right?
You do.
Okay. And this is, I think, an important point. And it's the point that I think for folks who may or may not necessarily be originalists in their review of the 14th Amendment, but are concerned about our overall constitutional structure, should really think hard about. Federalist 45 tells us the powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state. States have the police power. The federal government does not. The states have that power to protect life, health, safety, morals. That's vested in the hands of the state. And throughout our history, in fact, throughout Anglo-American legal history, that power has been used, among other things, to deal with the most weighty and serious and difficult moral questions we face as a society. Questions of life and death. Definitions of what constitutes life and death. To this day, every state has its own ability to define when the moment of death occurs and exercises that power. There is the Uniform Declaration of Death Act, which I believe has been adopted in 37 states, but is not federally imposed. When one is trying to determine the line between what's a persistent vegetative state and what's actual brain death or actual death, so that, say, organs can be donated or that life support can or cannot be removed. Those are questions that are left in the hands of state law. When taking of a life is criminal, when it's tortious, or when it's just simply a tragedy, is a question of state law. It was at our founding. It was prior to the 14th Amendment. It was at the time the 14th Amendment was ratified. It is still that way today. And until very recently, few have questioned that. So whatever arguments there are for challenging that in the context of abortion, they're not originalist arguments. They're not arguments about what the 14th Amendment of its own force does. They are contemporary arguments about what we may or may not want to do based on our own current views of what the law should be. As I mentioned, we have to say the 14th Amendment prohibits abortion. We also have to say that failure to prohibit it violates due process. I think that's highly problematic if we think state action is what due process is about. And as I already noted, the Due Process Clause of the Fifth Amendment, which is understood to have the same meaning, has never been understood to impose a duty on the federal government to prohibit abortion in those territories and places where it has that authority. The equal protection argument is an argument that, well, we have to treat the unborn and the born the same. But again, even within those jurisdictions that are the primary evidence of what the beliefs were in the 19th century about the status of unborn life, did not treat abortion and homicide as equivalent. Which, if we're saying equal protection is about treating the unborn and born the same, that this sort of distinction is unconstitutional and unacceptable, we would not expect that pattern. But in fact, we know that governments all the time make distinctions based on location, based on age, based on capability, and we don't believe that that violates the Equal Protection Clause. There are some Supreme Court cases of very modern vintage that say maybe, and sometimes it's rational basis with teeth or whatever else. But certainly we don't usually think of those as being an application of the original meaning of the 14th Amendment.
You got about 30 seconds.
I have 30 seconds. Maybe we'll get into section 5 during Q&A. Last point I want to make is this, and I'm glad Josh mentioned Lincoln and the importance of self-government. The Constitution, at its core, creates a framework and a structure for we, the people, to exercise our collective power of self-government, to make choices about what sort of society we wish to live in. And sometimes we do that at the federal level, and sometimes we do that at the state level. There's a disturbing tendency to believe that if we feel strongly enough about something, that it must in fact be taken out of that process and put in the Constitution. That if it's sufficiently grand and wonderful, it must be constitutionally required, and if it's sufficiently gross or obscene or horrific, it must be constitutionally prohibited. That's not the structure of government we were given. That is not the structure of government that was ratified. Rather, we were given a structure of government that requires us to get together in rooms like this, in government buildings and the like, and to hash out some of the most difficult and fundamental questions we face. I believe Josh is very well intentioned in his argument, but I think at the end of the day it fails and contradicts some of the fundamental premises of our constitutional structure, that these are the sorts of questions we must resolve through the political process, and they are not resolved for us by the Constitution. Thank you.
Josh, I'll give you 2 minutes to respond to Jonathan and then vice versa.
2 minutes, okay. So hopefully, first of all, everyone here sees this is like a real debate. That hopefully there's no one left who thinks this is just like a frivolous thing here. So 2 minutes, not a whole lot of time. I was taking a few quick bullet points. We'll kind of just dive in and then we could do the rest in Q&A, I guess. So Professor Adler properly recognizes that infanticide in common law was not treated the same as murder. That is true. I mean, in the commentary itself, Blackstone says that abortion, quote, though not murder, was by the ancient law homicide or manslaughter. At present, it is not looked upon in quite so atrocious a light, though it remains a very heinous misdemeanor. I'm not a 14th Amendment Equal Protection Clause specific scholar, but my reading of the 14th Amendment Equal Protection case law is that that is wholly consistent with the Equal Protection Clause. The Equal Protection Clause fully allows for varying levels of state level discretion over kind of the classic mitigating factors in a homicide, obviously, that you learn about in your criminal law all year. There's all sorts of mitigating factors. It's perfectly consistent for the 14th Amendment Equal Protection Clause to apply to unborn persons while allowing the states some swath of discretion to kind of apply those mitigating factors to infanticide in a way that they would not necessarily apply it to fully born post-birth persons, we might say here. Professor Adler notes something that Ed Whelan also noted in his replies to Professor Finnis, which I think is really interesting, which is kind of this notion that after the 14th Amendment was ratified, we don't see a whole lot of direct evidence in the legislative history linking the 14th Amendment to the post-ratification abortion proscriptions that came into place in the 1870s and 1880s. I'm not sure when originalists became fans of looking at legislative history. That's not necessarily my stance, but even kind of conceding the premise here, I think it's worth noting this is actually a higher standard than a lot of folks in originalist kind of right of center circles apply to other parts of the 14th Amendment. For example, of course, there's the Loving versus Virginia case. Senator Lyman Trumbull, who was one of kind of the foremost senators responsible for kind of drafting and promulgating the 14th Amendment, famously assured his colleagues that there was nothing in the 14th Amendment that would actually upset state laws that prohibited interracial marriage. And then, of course, Loving versus Virginia came. I think it's a correct case. I think most originals think Loving versus Virginia is a correct case. So I find it curious this is kind of a higher level of evidence that we're requiring in this particular context here. More
Good place to stop. You're 2 minutes wrong. John?
I'll just say, really quickly, I don't think we apply higher evidence. I just in time for today, I received hopefully I'll get paid for this plug, Randy Barnett and Evan Bernick's new book on the history of the 14th Amendment. If we look at issues that where originalist scholars have struggled or felt that there was kind of a mountain to climb to make an argument, we actually see very different sorts of evidence. So just to take Brown versus Board of Education, we do see discussion in the 19th century about whether or not it is a violation of equal protection or alternatively a violation or denial of privileges or immunities of citizenship for the government to create institutions with taxpayer dollars and then not to allow equal participation in those institutions. That was, in fact, we see that back in the 1860s and 1870s. My point here is not that one particular person or another particular person made an argument about how the 14th Amendment applies to abortion. I'm saying that people were debating what the government should or should not do to protect or not protect the unborn child throughout this period of time, throughout the mid-19th century. They were also debating the 14th Amendment. And we have yet to have anyone come forward and find anyone connect the two. And given the fact that the laws on the ground did not treat them as equivalent, i.e. did not treat the failure to prohibit abortion or to treat it equivalent to murder as somehow a denial of equal protection, and people didn't make that argument, is a conspicuous absence. Because I think we would agree that saying, Representative Smith versus Representative Jones, trying to figure out who represented the zeitgeist, yeah, that's looking out at the crowd and picking out your friends and quoting the people you like. I think it's very different when we just don't even see a question being raised about whether or not that's a fair way to interpret the language that was being debated, that was fought over, and that was ultimately ratified.
Okay, great. Thank you very much. I'll pose a question to each of you before we go to the audience. To you, Josh, if the unborn child is a person within the meaning of the 14th Amendment, would the Equal Protection Clause empower federal or state courts to evaluate whether state abortion laws could have any exceptions? Could have a life of the mother exception, rape exception, incest exception, health exception, disability exception?
I have to take the mask off, right? The short answer is no. My stance is not that the federal judiciary would be empowered to get kind of at that level of minutia here. Again, as I said kind of in my response to Professor Adler, this view of the Equal Protection Clause is fully consistent with a reasonable swath of legislative discretion to states. Obviously, not every murder statute, every kind of first-degree murder, second-degree murder, whatever statute is kind of verbatim analogous or equivalent, whatever, state by state here. Equal Protection Clause does not find a violation there. So no, my stance is definitely not that this would kind of empower the federal judiciary at such a high level where they could be making, where they could be making judgments about various abortion exceptions. Now, I do think, obviously, that excluding an entire class of persons, in Lincoln's time that was black persons, in our modern times unborn persons, from the protective scope of the rule of law is deeply problematic, for normative fundamental rights reasons, first of all, but yes, under the Equal Protection Clause, that would be my stand, but kind of getting to that level of specificity is not my claim that the federal judiciary would go in that level of detail. I do not, in a hypothetical world where 5 justices accept my argument, which is not going to happen to be clear, that I would not anticipate that happening, nor from my perspective should it.
Jonathan, my understanding of the Supreme Court's decisions on corporations being encompassed or protected within the 14th Amendment is that they also focus on the word person. And it's also my understanding that nothing in the legislative history of the 14th Amendment involved a discussion of incorporating persons within the debated 14th Amendment. So if the focus on person within the 14th Amendment can't contain the unborn child, can it contain corporation?
The answer is kinda. And you know, I'm not going to defend the way the court has talked about this question over the years in its cases, but I do think if one looks generally the way the courts have treated the concept of corporate personhood for constitutional purposes, as opposed to for statutory purposes, because as I assume you all know, in 1 U.S.C. 1, the Federal Dictionary Act, corporations are defined, the definition of persons for federal law includes corporations because Congress said so. That's also true in most states. But for constitutional purposes, the question really is whether or not the relevant constitutional provision or protection it has meaning as applied to people acting together in concert through a corporate form or through some sort of group entity or not. And I think if one looks at the case law, one generally sees the court applying that notion, which is again why self-incrimination is not something a corporation can claim. A corporation does not have the sorts of interests that would justify protection against self-incrimination. There has been no case holding that a corporation has a right to privacy, because again, there is no what people value in those things are not things that corporations value. But when we have constitutional provisions that are protected through the 14th Amendment, like the First Amendment protection on speech, which is applied to the states through the 14th Amendment, first of all, it's a prohibition on governmental action about protecting a certain type of activity. And the idea that if we band together, that if I band together with a group of my fellow citizens to create a group to advocate in favor of abortion rights or in favor of the rights of the unborn, and I take advantage of the fact that the law allows me to incorporate to do that, that somehow I would now have less rights, that the resources we pool to form that group could now be taken by the government without due process, that would actually compromise the rights of the individual persons who have collected together, which is why saying that the due process requirement that you can't take property without due process should apply to the resources, the property that we pool together in groups, just as it applies to us individually. So I think the underlying logic is there. I think it's fair to say the court has at times, especially in the 19th century, there's one case where it's kind of like given in a footnote, it just kind of glides by that understanding, but I think most of the doctrine is consistent with that, and that makes sense, right? Corporation doesn't add an extra person for apportionment purposes under Section 2 of the 14th Amendment, but when a group of people aggregate their property for some collective purpose, it still gets the protections of due process.
Okay. We're going to open up to questions from all of you, and I think the way I'd like to do it is if you'd ask a question to one or the other, and then I'll give the other one the opportunity to respond if they want. If not, we'll go to another question. Yes?
For Professor Adler, thanks so much for coming here and talking about this. My question is actually about your argument that legislative history and the lack of states' action, that those are really significant and possibly dispositive. How do those relate to the Bostock decision recently, where we might think that the lack of legislative history regarding whether discrimination on the basis of sex included sexual orientation, the lack of states responding in a way that suggested that it did at the time, doesn't that imply that Bostock was wrong to decide?
So a couple things. One, I don't think looking at ratification, the ratification period for constitutional provisions is quite legislative history. And it's actually, the inquiry is slightly different. I teach legislation and regulation, so like what's legislative history and what's statutory history versus what's contemporaneous evidence of meaning. I get a bit pedantic about maintaining those distinctions, but I think those are important. So my point there is just simply that if an issue was of the subject of debate, and modern debates about sexuality and gender identity that were not on the table when the Civil Rights Act was adopted. So the absence is open or not open to different sorts of implications than it is today. Or than it is when we're talking about this question about 14th Amendment, where this was all on the table and people weren't making the connection. And if we want to understand what the original public meaning of those words were, we would at least have a question about why no one's making that connection, right? We would, if people were doing things that were contrary to the public meaning of those words and debating those very same questions, we would expect there to be some evidence of somebody making the connection. Bostock, though, is ultimately a statutory case. It involves a different inquiry. It's also a case where the strongest we could have a whole session on Bostock. I'm skeptical that Bostock was correctly decided as a matter of statutory interpretations, and I'm not convinced that's what the language means. I think there are arguments in support of the outcome in Bostock that are actually different and substantially more sophisticated than Gorsuch provided. Because in the statutory context, we care a lot about statutory stare decisis. That is to say, our doctrine says we're not allowed, the court doesn't revisit prior statutory holdings, and there are legitimate questions about whether prior statutory holdings interpreting those provisions of the Civil Rights Act foreclosed a kind of an original meaning of the language interpretation that was offered by the dissents. The majority doesn't get into that, so would those arguments ultimately be convincing? My answer is maybe. But it's, I think, fundamentally a different question.
Do you want to respond, Josh, or want me to go on to another question?
I mean, I'll add one quick point. I've written voluminously on Bostock, so I'm not going to talk about Bostock. But when James F. Wilson, who was House Judiciary Committee Chairman, when he introduced the Civil Rights Act of 1866, I mean, while we're kind of, I guess I'm a little less pedantic about this legislative history distinction, but kind of while we're going back to legislative history, he says, again, this is the Civil Rights Act of 1866, what the 14th Amendment was meant to constitutionalize. He says, quote, "These rights certainly must be as comprehensive as those which belong to Englishmen. Blackstone classifies them as follows: the rights of personal security, great fundamental rights, the inalienable possession of both Englishmen and Americans." And as I got to earlier, literally commentaries begins with the rights of unborn persons. So I think the legislative history at best cuts both ways here.
Yes.
Yes, thanks, finally a woman speaks. So Mr. Hammer, this question is for you, and this is assuming, my baseline assumption is that the beginning of life being at conception is a different concept than personhood for me, so that's my initial assumption. So if we look to the original intent then to find this, and we see at the time that many people would say that women were not included under the 14th Amendment, the definition of person there. If we're including the unborn child, that means that immediately when they were born, if they were born female, then their status has somehow been diminished because now they were female than when they were an unborn child, that they could have been male or female. I'm just wondering if you have a response to that, if that's the sort of intent line that we're going.
I suppose there was a question somewhere in there. So I'm not an original intent originalist, to put it mildly. I have a whole competing theory on originalism I subscribe to. You can check out the Harvard Journal of Law and Public Policy from this past summer for my thoughts on that. What is the purported originalist argument that women are not persons under Section 1 of the 14th Amendment? I literally don't know what it is. Do you?
Well, I mean, just the presumption that if you're looking at how laws have been applied to women, and particularly thinking about like how strict scrutiny is treated differently than intermediate scrutiny for laws that apply to gender, there is a sort of different line, and laws that have treated women differently than men have been subject to different meanings under the.
And this is a purported original intent originalist argument. How?
It's just the intent that the legislators at the time did not say that all persons were encompassing the women, much like a person who attains the age 35 to borrow from the presidential thing. No one would have believed that that would have applied to women at the time that they could go and be president. So it's on that line.
Okay, I'm hearing a lot of baseless speculation, a whole lot of questions. I think that we can move on, honestly.
Would you like to?
I think the language of the 14th Amendment, its original public meaning, did apply fully to women, and that cases like Bradwell were wrongly decided, but wrongly decided for the unwritten opinion, the reasons that Justice Chase left unwritten because he was too ill to write a dissent, not the reasons in the dissent which you may read. I don't know how many of you were assigned Bradwell on con law, but who got Bradwell in common law? Yes, no? No one. Okay, so case decided, just real quick, decided the same day as the slaughterhouse decisions, which I hope gets assigned in common law. A more simplifying slaughterhouse case, you don't have a right to be a butcher, so the state can allow a monopoly. Bradwell decided the same day. Myrna Bradwell wants to sit for the bar in Illinois, and she's told she can't because she's a woman. The court rules against her. The majority says if you don't have a right to be a butcher, you don't have a right to be a lawyer. Three of the slaughterhouse dissenters are kind of stuck because they think all persons and all citizens, of which she clearly was, have the privileges and immunities of citizenship. So they write this really awful dissent about, well, women are different, which clearly was a view that was widespread by many. Justice Chase dissented, but would not join the sexist dissent of his colleagues. And what we think we know of his writing and thinking at the time is that he was going to write an opinion, which I think would have been correct, which is persons who are citizens are entitled to the privileges and immunities of citizenship, and that includes the equal ability to pursue a profession. Myrna Bradwell should be allowed to be a lawyer. And for people that are interested in that, Randy Barnett has a piece in the Case Western Reserve Law Review on the history of Justice Chase that gets into that and what we think his dissent would have said. But I think the language there is clear. Right? There was no dispute that women are persons for legal purposes. I think the question I made at the beginning, that from a textual standpoint, whether or not biological humans are persons for legal purposes of the Constitution, is not answered by the fact that James Wilson in the 19th century said, hey, I really like Blackstone. And if we go back and look at Blackstone, we see Blackstone saying certain things about the unborn. That doesn't establish the legal meaning the way I think it should have, and the court very belatedly recognized for regarding women.
Question. Hold on. Yep. Two real quick things. So I guess I have to state the obvious here, which is obviously women are persons under Section 1 of the 14th Amendment. I can't believe you don't have to say that. I mean, that's kind of why I didn't hear a question in that question, I guess. And honestly, Section 2 of the 14th Amendment is actually great evidence for this while we're kind of going around the Constitution finding other evidentiary places to cite. Because Section 2 expressly is referring to proportional representation. It refers to quote-unquote male citizens as kind of a criteria in how proportional representation is defined here. So the same people obviously drafted Section 2 that drafted Section 1, where they refer overtly to kind of one sex in Section 2, we can therefore, as a basic canon of construction, imply that person in Section 1 obviously, transparently refers to both male and female. I'm surprised I have to say that, but I think that's so obvious. But just extremely quick on the lattermost point here. We have like 2 minutes left. You can go on.
Okay, right here.
Yeah, so obviously there's been a lot of legal argumentation made, and obviously it's been very abstract, like the meaning of the 14th Amendment. But I think that this is something that affects people in the real world. You can't extricate it from the politics of it. The Federal Society and this whole debate is really engendered by the rise of the Christian right. So I'm wondering, this is specific for Mr. Hammer, what does the world look like if the court were to agree with you and to rule that the 14th Amendment prohibits abortion? What does it look like every day for women? What do you want what is your vision of the world, essentially, should this legal argument become popular?
What is my vision of the world?
Yeah, what does it look like when a woman
Is it a philosophy class or
gets pregnant and doesn't want to have a baby?
Okay. So first of all, it's a nice Jewish boy who literally travels with his tefillin and daven's every single day. I can't speak for my brethren in the Christian right. What I can say is that if my interpretation of what I'm espousing here were to take hold, it would be a huge civil rights victory. It would be a huge victory for an entire class of human beings that are not currently protected under the Constitution, as my argument implies they should be here. And it would dramatically limit and reduce the number of unborn children that are murdered in the United States of America. That is my vision. Obviously, I have a vision that would support kind of crisis pregnancy centers. I've been emphatic over the years. I've written at great length about how people who agree with me on the underlying abortion issue need to go out of their way to support pregnancy centers. I have personally donated to many over the years here. So there's any number of kind of concrete ways that people I think ought to be compassionate and very sympathetic in talking about these very difficult issues here. But at the end of the day, what my vision ultimately redounds to is that an entire class of human beings that are not currently protected under our great charter, the Constitution, would be protected under that document.
Jonathan.
You're real quick. Not to return to the legal points, but I don't think it's that simple, and for a bunch of reasons. I mean, for people that are interested, I recommend reading the amicus brief that Robbie George and John Finnis submitted. It is one of the fuller explications of the theory that Josh has put forward. And you get 30 pages of history, and you get a page and a half of, oh, well, this really wouldn't unsettle very much legally. And the reality is it would either do nothing, because the court would have said the unborn persons and states, shame on you, or we have a world in which federal courts are being asked and dragooned on a regular basis, revising, reconsidering, reapplying, and altering state laws, considering whether to allow state executive officers to violate the understanding of the laws within those states, and modifying laws. And Finnis and George hinted this a couple places and say, oh, this is not a big deal. Actually, it's a pretty radical deal. And for those in the audience who kind of have an underlying view of what federalism is about, and recognizing that a federal system sometimes means that some states allow things or prohibit things that you think are really wrong. That's the nature of our system. And that having the Supreme Court try and do this by reinterpreting the 14th Amendment would actually have radical implications for the way our legal system operates. And so that even people that are otherwise things like the argument need to think really seriously about whether or not that's a role for the federal courts that they want.
Thank you, Jonathan. Thank you, Josh. Closing comments.
Thank you, Clark. Thank you, Josh. Thank you, Thank you.